Hello, hello, hello. Oh, this is the 41st City TV presentation of the round table. Today we are discussing, today we'll be discussing Article 73 of the Liberian Constitution. So keep tuned. We are going to start very soon. I don't know, Abijay Radio, are you there? Mr. Tor Griffiths? Hello? Hello?
Everything is said. Okay, okay.
Are you hearing me?
You're live.
Okay. Once again, this is the 45 City TV online presentation, and folks in Radio Land, welcome to another fascinating conversation of the round table. The discussion today will be discussing um, Article 73 of the Liberian Constitution. And we want to use this time to welcome all our online viewers and those in Radio Land. We have RadioTV Radio there. We also have Liberty Radio, and very soon we'll be having the Voice of Cleveland. And as we continue, our panelists will be coming on. I want to use this occasion to welcome Mr. Tor Griffiths.
I'm right here, my brother. Thank you.
Again, this is Solomon Frank Kwame. I am anchoring for the host, Pastor Patience, who is on an official assignment. So today I'll be anchoring, and we will be discussing the provision in Article 73 of the Liberian Constitution. So first of all, I want to welcome you, Mr. Tor Griffiths. Mr. Tor Griffiths, welcomes to the live broadcast.
You're welcome, my brother. Thank you.
How is it from your end?
Very good. You hearing me, Claire?
Loud and clear.
Thank you. I wanted to know that. Here is very beautiful. Little drizzle of rain. That's it.
Okay, that's good. That's good. I don't know if I could get any signal from Liberty Radio.
Not yet.
Okay, what's about the Abijay?
Yes, everything is said. Everything is said.
Okay. So, like I said, again, this is the 41st City TV presentation of the roundtable discussion. Today, we will be looking at Article 73. We are very hopeful that our panelists will be coming on very shortly. Yeah, we are. We have Mr. Tor Griffiths, one of the panelists on this show. We have Obligate Radio there in Grand Bassa, relaying this program live on radio. We also have Liberty Radio there in Monrovia. We also have Voice of Plebo in Plebo City, Maryland County. Today, we will be discussing the provision, Article 73 of the Liberian Constitution. Welcome to the conversation, Mr. Tor Griffiths.
You're welcome.
Okay, RDJ Radio, if you are hearing me, what are some of the training issues out there in Grand Bassa?
Currently, as we speak, there is no training issues. Everything just the same right here as usual. So we just keep moving. And today, Obligate Radio, we were on the street. We're on the field today getting Celestine's view of citizen concerning the reconciliation of the Liberty Party as they have started. So it was a great time. We got some citizen view, and they were like interested in the information that were presented to them about the reconciliation of the hierarchies of the Liberty parties. as they are trying to come back together. So citizens were like happy. Yeah, that was the information we gathered today.
Mhm.
Thank you so much. Thank you so much. That is our correspondent there with the RBJ Radio and online TV there in Buchanan, Grand Bassa County. If you are hearing me, Liberty Radio. Is there any information from your end? Okay, as we await Liberty Radio and that of Voice of Plebo and our other panelists, Mr. Toll Griffiths, welcome again to another fascinating discussion. Today we'll be discussing Article 73 of the Liberian Constitution. What is your
Thank you.
intro?
Yeah, my intro is simple and to set the basis. The immunity pronounced upon the judiciary branch is exclusively in the line of duty. In the line of duty, him or her is immune of civil or criminality based upon their judgment and intuition according to the descriptions of their work. But what I want to make clear is that anything outside of their work, if it is a misconduct contrary to the civil law or criminal law of Liberia, they can be prosecuted. And let me make this clear in about 30 seconds. The judiciary are not immune from prosecution, just like any other citizen. If they are not working, that is, for example, in the home of the judiciary, if it is alleged that they extorted someone that may take anything from anybody or take away life, him or her will be prosecuted. So this is the misunderstanding that many Liberians have, that if you a judiciary member, that means a court clerk or the judge or an administrator in the court, you are immune from your duty. And the law is to give them the free will to be able to administer justice freely, not having to be sued after they are done their job. But anything after their job, they are just like any citizen that can sue and be sued.
Okay, thank you very much, Mr. Griffiths. Before I can bring in RBJ Radio, I would accept they have something to introduce here on this topic, but I will read for the benefit of our listening audience there in Radio Land and those that are watching online. Again, I say you are most welcome to another fascinating discussion of the round table on the 45 City TV platform. I'm anchoring for the host, Pastor Patience. She is on our official assignment. Today we are discussing Article 73 of the Liberian Constitution. If this provision needs to be amended, or what is wrong with it, it is a conflict of interest, or it is conflicting itself, I will read for shortly. We're supposed to put it on our screen. I hope our technical team will do that shortly, but let me read from here. They say no judicial official shall be summoned, arrested, detained, prosecuted, or tried civilly or criminally by or at the instance of any person or authority on account of judicial opinions, render or express judicial statement made and judicial act done in the course of a trial in an open court or in chambers. Now, they went on to add that except for treason or other felonies or misdemeanor or breach of the peace. So before I go to Mr. Griffiths to ask this question, RadioTV Radio, are you there?
Okay.
Okay. Please announce the numbers when calls are coming in. Please announce the number. I mean the calls the line is will be open very shortly. So announce the number for folks to call. So I don't
Okay.
know what is your take on this provision that talk about no judicial officer shall be summoned, arrested, detained, or prosecuted or tried civilly or criminally. They say in line of their duty, except for misdemeanor or felony or breach of the peace. We will come to bit by bit to discuss it. But what do you think of this?
Okay. So is a open statement. The article is trying to portray that states that judicial statements made and judicial acts done in court of a trial, open court, or in chambers. So, as a lawmaker, once they are a lawmaker, and then working at the time when they are at work or uh, serving, they cannot be persecuted when
Okay.
it is in their job site or, for example, in the chambers. So, open court or in chambers, we mean when they are making rules or regulation, if they are making law, they cannot be persecuted for such act because they are in the interest or they are representing their constituents, their people from diverse background. So in that means they shouldn't be persecuted or they shouldn't be taken to court for whatever they say or whatever they do there.
Okay,
That's
thank you
why
so
they
much. Thank you so much. So, can you please announce the numbers so that if calls are coming in, just let us know. Because this show is the people show. This program is for the people. Because we are discussing blanket constitution. I mean, blanket provision within the constitution that we think that would need to be discussed, needs to be amended. So when calls are coming in, just let us know the calls are coming in, and then we will pause and allow the people to edit their views.
Okay, so let me announce the number. So for our listener in Grand Bassa County, if you are there, there is a 45 City TV, and we are discussing Article 73 of the Liberian Constitution. So if you are interested to call, you can call the number 0775 734 774, 0775 734 774, 0881 166 731 to partake on this discussion this evening.
Thank you so much. Thank you so much, Ablijay. So you, Mr. Griffiths,
Yeah.
uh, are we saying in short that this provision is conflicting because they say no judicial member of the judiciary, shall be summoned, or any judge shall be summoned or arrested or persecuted. But now we ongoing, they talk also about misdemeanor. They talk about breach of the peace. They talk about felony. How can you reconcile the two?
Yes, I wanted to make a brief clarity on our brother from Ablige Radio, what he said. Sometimes even myself, we misunderstand, we interchange the judiciary from the legislatures. So I wanted to make that clear because when he was speaking, he was talking about the legislatures, the representative and the senator. But we are talking about the judiciary right now, not the legislatures. The judiciary is the court. The court. What happened in the court? That means the judge, in America we get a district attorney general. That means, so whoever public defender, right? So we're talking about the judge here, the public defender, and the court clerk, the court administrator, all the people that are working in the court system being immune with the judgment they are rendering. So we're not talking about the legislatures. who are the representatives and the senators that we elect. So I just want to make that clear. However, with the question that you asked, that is it conflicting? I would say no. As Ablige Radio brother said, it's an open statement. I agree with him, it being an open statement. Furthering that there's a room for discussion. There's a room for discussion, meaning that's what I said from my introduction, that if they are doing a work in the court that they are supposed to do, they will not be charged. But their office has rules and regulation. Their office has scope of limit. So when they go out of the boundary, the scope that the Constitution has allowed them, then there will be the breach of the law. It will make inflammatory statement. And if their statement can directly or indirectly cause, for example, popular uprising, and then there's a loss of life, and then there's a destruction of property, then they can be called to order. That being a judge, being a popular defender, does not make you to make inflammatory statement, and making the inflammatory statement broke the peace, and therefore you can be charged with misdemeanor. I will break right there. I want to go far, but I can break there if you had input.
Okay, so thank you very much, Mr. Griffiths. I think this provision, somebody may argue to say, oh, why is it that it is talking about judicial member of the judiciary? Why is it that they are immune to be prosecuted? Why is it they are immune to be summoned? Why is it they are immune to be detained in discharging of their duties? And then somebody will come out and say again, but they say except for misdemeanor. So I think in my view, this provision is very, very clear. So my question to you, Mr. Griffiths, will be, do you think that this provision need to be amended, or it is just clear as what crystal?
Yeah, this can be amended or improved upon for clarity for the Liberian people. So one thing I want to say is that the public, the citizenry of Liberia, they need to be acquainted with their constitution, and they should be able to discuss it as we are discussing it, so that they will not be told lies. Because one of the myths that people have is that if you are a judge, you cannot be charged, you cannot be prosecuted as long as you are a sitting judge. That's not what the Constitution says. Yeah, hello?
Yeah, go ahead. I thought calls were coming in.
That's not what the Constitution is saying. The Constitution is not saying outside your work hour. For example, let me make it very crystal clear. For example, if the judge is working from 8 a.m. to 6 p.m. and they are in their chamber and minister justice between the 8 a.m. and the 6 p.m., everything the judge said in his chamber, they cannot be prosecuted for it. Let me make that clear. Okay. But after 6 p.m. and that judge goes home, and let's say 7 p.m., something happened, and the judge fought somebody on his way home or in his house, that person he fought has the right, if they feel that the judge caused the problem. That person has the right to go to court, go to the police, and lay a complaint. And that complaint can go to the court. And that judge will be charged in another court of jurisdiction.
Thank you very much.
I want to make that very clear.
Thank you so much. Thank you so much. So before I go to Ablige, maybe he has something to say concerning about this. We are talking about Article 73, folks. If you are just joining us, folks, in Real Land, today we are discussing Article 73 of our Liberian 1986 Constitution that talks about no judicial official shall be summoned, shall be arrested, shall be detained, or shall be prosecuted civilly or criminally, or at the instance of any person or authority on account in them discharging their duties. Now, somebody may say, why if it is alleged when a judge is discharging his duties, for example, he did not do due diligence, like people were saying of recently concerning the case of George Chinner of Criminal Code B. People were saying that, there was some malpractices, surrounding the judgment of Jessica Law and Lucas Riches, in that light, you think what should have been done? Let me hear from Ablige. Ablige, do you want to have your say on this?
So yes, that was the same point. That was the same basis I was laying, trying to relate it to the lawmaker side. Yeah, because they are the same people working for the government. So I will laying the basis on the government side, saying like the lawmakers also, trying to put it in that range. But the articles is actually trying to say that no judicial official. So in this case, like he previously stated that when they are at work, whatever they do there, they cannot be prosecuted for it. But if they leave by 7 and get for another services and then happen to commit a crime, they can be prosecuted.
Okay, great. Okay, great. Thank you so much. Continue announcing our numbers. Like we said, this show is a show for the people. What makes a country great is the Constitution and the laws make that country great, so that the law can be as the watchdog, for people to do.
Good afternoon. Good afternoon. Can you hear me?
Yeah, go ahead. Yes.
Yes, I want to ask a question. Yes, because they come to my office to cause trouble, and you run away in the morning to go somewhere. I have right to carry police officers to arrest him.
You got a question?
No. Can you please echo it for us?
He said, what if a judiciary having to commit a crime in the next time, and then he went at his job site, at his office, and then having to take police there, can he be arrested?
Okay. Thank you very much. Is
Can I
there
help you with
there any more coming again?
No.
Okay,
Okay.
Mr. Griffiths.
Yes.
I think you heard what the caller talks about. Can you wait on that?
The answer to you is no. You cannot go to the court while he's discharging his official duty to make an arrest or an inquiry. You cannot. But after, as I said, if it's assumed that his working hour is, for example, 8 a.m. to 6 p.m., I'm just making an example between the time range. You can wait after he gets home. You can now go there and make an inquiry. Now the police, when he gets home, the police now has the full mandate between, for example, he get home 7 p.m., the police can go and knock at his door, and he, just like any other citizen, must open the door. And if he cannot open the door, the police need to go to the court and get a warrant of arrest or a search if it is alleged that he has any offensive item in his house or something that will be able to incriminate him that in his house. They can go to the court to get a search warrant. And I'm saying search warrant from the court is not just limited to the judge. Any Liberian house cannot be searched by the law enforcement agency except the law enforcement agency has obtained a search warrant from a court.
So, Griffiths, let me hold you there again. This is the 45 City TV online conversation. We have our sister radio station, the RBJ radio station there in Buchanan, Grand Bassa County. They are anchoring, as well as the Liberty Radio. And that we're sorry today we can't get Voice of Plebo. But again, we are discussing Article 73 of the Liberian 1986 Constitution that talked about no official of the judiciary shall be arrested, summoned, or persecuted for act done in line of their duty, except on grounds of misdemeanor, breach of the peace, and that felony. What we'll come to in the second half of this discussion. So, put in your calls. The WhatsApp number is there on the live feed. You can call if you are in the diaspora, or if you want to call on WhatsApp. The WhatsApp number is there in the live feed. Let's make this conversation interactive. Again, RBJ, if you get any call coming in, please feel now to let us know. This is the People Radio. This is the People Discussion online TV. Again, Mr. Griffiths, the point here is what the caller was trying to make here is the point the caller trying to make here, Mr. Griffiths. The caller is talking about in the night when he is home, right? When he is home. And come in.
Hello.
Hello?
You are live. Let's hear you. Your name, where are you joining from?
Yes, my name is Sonoma Moses. I did join you from Mancosun community.
Are you following the discussion?
Sorry.
Let's hear you.
Yeah, I would like to think the panelists for the level of articulation on the issue. But I have a concern. And my concern is there was example maybe someone woman or someone with my daughter and I carry the coat and they told a pizza on a call to get money. The kids went against me. So what we have to can I sue the job or what I can do?
Thank you.
Question?
Yeah, we got a question.
Okay.
So, if someone rape your daughter, is a criminal matter that can lead to a felony charge. You had a right to be addressed, and the court had a right to issue an arrest warrant for whoever is allegedly done that. And remember, that person is allegedly innocent until proven guilty in the criminal code of law. So, let me explain this to you. The court system has so many 100,000 and hundreds of thousands of cases on their log. So they will arrest this person and arrange them. And because the court cannot judge that particular matter in due time, the Liberian law affords that particular Liberian citizen to be able to afford a bond. Then if that person lawyer want to have a bond hearing, because the court is unable to try that case as fast as possible, they'll have a bond hearing. And if that person is not a repeated offender, the court will give that person a bond, and the person will go home, but the person not free, and the court will give the trial date for that particular case. It might take a week, a month, or a year, so on and so forth.
Okay,
So
thank you.
that's right. So
Thank you,
in that time that the court is set, that person will go to court. But definitely, the person have to face a day of court, a day of reckoning in court. If it is not done in that jurisdiction, then people need to be angry and be able to express themselves with social disobedience until the court can do their job. Thank you, my brother. I want to end the statement there.
Good afternoon.
Good afternoon. Daniel wants to hear from Ghana.
Let's hear you.
The question the previous caller asked, the way you answer it, I just want to better. He is trying to say that I gave my case to the judge because I don't get money. The case is in the door me to for me to get bail. Because of no money, the judge went and wrote against me. Can I say answer against the judge? That's the question he's asking.
Oh yes. I'm sorry. If the judge does not try the case, it's an offense. And that judge must be demonstrated against. Whoever appoint that judge must be removed from being a judge there, because that judge violated their oath of service. And then after that judge is removed, that case can be trial.
Okay. Thank you so much, Mr. Griffiths. Again, today, this is a 45 City TV production online platform. We are on the roundtable. We come on every Tuesday and Thursday. We are discussing provisions within the Constitution, I think, that need to be discussed, whether it need to be amended. We want to welcome Dr. Gompu, our professor. Welcome Dr. Gompu to another fascinating discussion of the roundtable.
Thank you, Solomon. I'm happy to be here.
Okay, before we can dwell on the article itself, there is this question from our callers. You know, most of them are asking about Mr. Griffiths for weighing in. They're asking if for any reason, or maybe someone who have money, their child was being molested, and the case is in court, and perhaps the judge is playing caricature of the case now, and the judge ruled, and all evidence showing that yes, the offender committed the crime, but the judge ruled and said not guilty. The callers are asking, what is the next move? What should they do, Dr. Gompo?
Yeah, I think again, I'm not a lawyer and do not know some of the technicalities of the law, but generally the law provides for what do you call it? There's a term for moving the case to a higher court. When the judge issues an opinion that the victims or the family of the victims feel is unfair, I think the judge can ask for the case to be elevated to another court. And I don't think, normally for criminal cases, something like a rape or something like that, it is the government that is trying the case against the defendant. So it's the Justice Ministry that is prosecuting the case against the defendant. The relatives of the victim or the victim themselves do not get directly involved. They usually tend to support the prosecution in terms of being witnesses, to be able to testify in court if needed. So when the government feels that, so in other words, the government is the victim's lawyer, and if the victims are not satisfied with what the judge ruling is, I think there is a way in which they can express that to the Justice Ministry to ask for another trial at a higher court, or there are other ways in which they can file a complaint to talk about some of the behavior of the judge with respect to how the case was conducted. To say, for example, there was foul play, maybe there was bribery or something of that nature, something that is illegal.
So that's it. Thank you so much. But there are some concerns, right? Why if, like, I will give example, but let me ask this question: why if the Ministry of Justice, yes, the prosecuting arm, alluded to what judge ruled, and victim family is saying no, we disagree, but the prosecuting arm alluded, say, okay, yes, sir, to the judge, like in the case of Dick Cheney and Jessica Law. What is the next step? Does the legislature come in to call that judge for inquiry, or?
That's a tough one.
Oh.
That is a tough one, because again, the family themselves are not the prosecuting arm. And if the family wants to prosecute the case themselves, then maybe they can file a civil lawsuit. They could file a civil lawsuit against, like in the case of that Jessica Law thing, civil lawsuit for damages or something like that against the reverend. I don't know whether he was a reverend or what he was. Okay, in that case, then they will get their own lawyer to pursue the case. But the criminal act committed in terms of the attempted murder, you who was attempted against cannot take that case in your hand to go to the court to be the complainant. The government has to be the complainant for any criminal case. So in the case where the government itself connive, if the justice connive with the defendant, then I mean that's another case by itself, where I think the family could file a complaint either with the president or with their senators, or that is not in the law to say.
Yeah.
But because I mean the Ministry of Justice, when you are a victim of crime, they become like your lawyer. So if your lawyer turns against you, if your lawyer does not work for you, your lawyer takes bribe and turns against you, then that's a malpractice. Then you have to go to who employed that lawyer, who is the president or the Senate that have oversight on that person's employment. So that would be my recommendation.
Thank you so much. Before I get to Mr. Griffiths, but I will stay with you one more, Dr. Gonku. This Article 73, what is talks about no official member of the judiciary shall be arrested, prosecuted, or summoned for any reason except on grounds of misdemeanor, breach of peace, and that of the felony. What's the overview thought of this provision?
Well, yeah, I think my view of it is that it's a good provision, because it's basically trying to make the judiciary independent, because it's focused on the opinion the judge gives in a case. And it's basically saying that if you give an opinion in a case as a judge, you should not face any prosecution because of that. So, for example, somebody sues the president's cousin, and then you, the judge, and then you look into the case and you say the president cousin is wrong, and you send the president cousin to jail, or you file charge, you ask for a fine. The president, even though is the leader of the executive branch, the president cannot come after you to say, Judge, that was my cousin. Why did you rule against my cousin? Or basically ask for you to be dismissed because you rule against his cousin. I think that's what that article is saying. But I understand that although it's intended to protect the judiciary so that the judiciary can be independent in their view, not be afraid of political pressure, and to look at the facts in the case, it could be abused. And so that's why if we're going to do some reform, maybe the idea of considering something like a term limit, which the Americans are considering now for the judiciary, could be a good thing. Because sometimes when these people have this, unlimited tenure, you see, so even if they're behaving badly, their term cannot come to an end. They're just there for the rest of their lives, you see. So maybe if we're going to do some changes, we can say, okay, we limit their term to maybe 10 years or 9 years, for the judges. So that way they can know that they need to be reappointed or they need to be reelected.
Thank you so much, Dr. Gompo. Was insightful information. Again, this is a 45 City TV discussion program, a roundtable. We are discussing Article 73 of the Liberia 1986 Constitution. Our sisters radio stations there. Abli J, if you get any call, please don't fail to let us know.
Okay.
Okay. So, Mr. Griffiths, but let me just list it. For example, breach of the peace. I am a judge, of any of the lower courts. And I go home in the evening time. I bring my speaker in the community, play music, and I just disturbing everybody. People say, oh, this, that, this. And they decide to persecute me, or they decide to take the case to court or call police because it's first start with the police. Now, in your reading, what you think should be done in that case? Is the judge going to say, no, but I have my right to play my music. I have my right to enjoy myself. Why is it you people ganging around to say I'm breaching the peace? Does that fall on a breach of peace?
Yes, that fall on the breach of peace because the civil law of Liberia constitutes behavior of every individual in the community. And we always misquote it where your freedom end and where another man's freedom begin. We always, do our colloquial way of saying that. There's an amount of noise you can make in your house or in your domain, your property.
Yeah.
And if that noise exceeds the popular amount that's supposed to come from your house, a neighbor has the right in Liberia to call on law enforcement to speak to you about that conduct. And if you will not obey the police mandate to reduce the sound, the police has the right under the law of Liberia to arrest you, even if you are the sitting judge in the community.
Let me pivot a bit. Let me come to that Gompo. What crime has this official of judiciary committed that you think he need to be processed by the police or processed for any reason that he had done in a yard, maybe playing music loud, preaching of the peace?
Yeah, I agree with Mr. Griffiths that the immunity is limited to decisions rendered in a case. Opinion rendered in the process of doing your work. But when you leave the court, you are a citizen, even though you are still a judge, but you are a citizen in the community. You are expected to be of good behavior and you're expected to have the same rights as other citizens. You cannot go out there and order somebody beating or disturb the peace or drive recklessly, drive under the influence of alcohol. You see, and that even this issue that you're discussing now, it even extends to the issue of like religious houses. There are some religious houses in Liberia that when they are having their religious ceremony, I mean, they beat the drum so loud, or they use even loudspeakers for the whole town to hear them. You see? Now, other people have other religions. So if you are exercising your right, your freedom of religion by, making your announcement or using a very loud speaker that make other people not to have their peace, I think that should be a concern too. So in other words, the same way in which the law limits some of the ways in which ordinary citizens can exercise their freedom, those same laws apply to the judge as well.
Okay, so somebody may argue, and anybody can chime in on this. Somebody may argue to say, oh, but if I, for any reason, breaching the peace, it should be a civil case. It is after 6. this is not a criminal case. So I don't think you can gang up police for me. If you think I have done any wrong, you go to the court. And, so you can see get a warrant of arrest. But it is after 6. It is not a criminal case. How do you reconcile
that? No, criminal case is criminal case.
No, I mean, if the case is a civil case, if, for example, breaching of the peace, plain you saying that, the man is saying that if you think I have done wrong, then this is not criminal. You can go to the court and seek warrant.
No, this is what I said. I fall short of, saying they can shut it down. So the police is the authority when they arrive everywhere. And every citizen must obey the police in their professional duty. In their professional duty, if the police says you need to turn it off or lower it, and you refuse to lower it, you have disobeyed a police command. And if you disobey the police command, under the discretion of that police officer with the intensity of that matter, that it might cause public disruption, they may call for a public peace. The police, under their discretion, may turn that off and confiscate that property and take it away to the police station for that night.
Okay.
Or if they don't want to do that, they can arrest you when they try to turn it off and take it away. If you try to stop the police in their act of duty, they will arrest you and take you to jail.
So, you that you can come in. We are talking about the official.
Yeah, you can come in, my brother, senior brother.
Yeah, I think everything he's saying is right. And I think again, government official, judge, member of the House of Representatives, senator, or whatever. First of all, you have to be a good citizen. Good citizenship implies that you abide by the law. And if you are not aware of the law, other citizens can inform you about it. So if you are a neighbor and somebody is making heavy noise, I think your first step will be to approach this person cordially and say that we are trying to get our peace. While if you have your party, the noise is excessive. If the person does not obey, then you call the police, and the police comes in. The first thing will be to warn this person that judge, your neighbors are complaining. Your party is embarrassing them because their children are preparing for school tomorrow, or they're sleeping and they have to wake up early to go to work. And if you continue, then the police can arrest you. I think that provision allows for that.
Okay, so again, WJ Radio, thank you very much, Dad. WJ Radio, if there is any call, please let us know. Dad, let us come to the court. Okay, do you think this first portion of Article 73 that talks about in the judges discharging their duties, do you think they serve as one of the reliance for some judges to surreptitiously, discharge their duty? Do you think that is their reliance?
No, no. I think this article is basically just saying that your decision should be independent of pressure or of fear that if you rule this way or you rule that way, somebody will be disappointed, and because that person has power, they're going to retaliate by, maybe calling on the president to dismiss you or calling on the legislature to impeach you. I think that's what this article is about. You need to have that judicial independence, and the way to have that is to say no one should be prosecuted, no judge should be prosecuted for opinions rendered in the whole process of doing his duty as a judge.
Yeah, but again, I will say it again. Now, let me ask a hard question. I will come to you, Mr. Griffiths. Let me stay with that Gumpu. Let me ask the hard question. I'll play the devil advocate here. Now, you are a judge, or let's say a judge. All evidence proving beyond reasonable doubt that his judgment is contrary to what was being proceeded in the chambers. But you have this rely. I agree, without fear or favor, you should render judgment. But his judgment is contrast to the evidence that are on there. And I will give you an example. At the magistrate court in Newtown, sometime in 2010, okay, there was this alleged armed robber, who they call him money-making machine, was committing a lot of crime in the community. But people understand that his girlfriend, uncle, was the magistrate. And all evidence show beyond that, and the man said, no, the man get it. It was not small uproar. At that time, we stay high on me kind of come in, not easy. Fire tear gather, all that kind of thing. So I'm bringing it this, I use it this. Why if the judge, because the judge think that, the magistrate think that, okay, this is my reliance. Nobody can question me or to summon me or prosecute me in my decision. Now, for any reason, he goes to take money, bribery, go take something. I mean, beyond. And can't render judgment. What do you think?
Well, the thing is, people can always abuse their power, whether that provision was there or not.
Right.
See? So even if that provision was not there, even if the judge had a senior person who could reprimand him, and if he decides to abuse the position, he can still do that, right? He can still do that. But the way the courts are set up right now, the judges have, I think there's a structure.
Yeah.
There's a structure because, when there are cases and the judge is not responding the way he should respond, there can be appeal to a higher court.
The higher court, yes.
Now, when you appeal to a higher court, the higher court can reverse the decision of that judge.
Lower court, yes.
And if that happened 2 or 3 times, it will indicate that the judge is incompetent.
Right.
You see, if your decision are reversed several times by upper level court, the implication will be that you don't know what you're doing, and you could be removed, or you could be reassigned, or you could be. They have their way of punishing, people.
That's right.
Okay,
Yes.
thank you so much.
Yes.
Yeah, thank you so much, Da. Mr. Grateful for come to you. RadioTV Radio. Again, this is a 45 City TV discussion on the roundtable. We're discussing Article 73. And I think the article is that most of our panel is saying that the article is very clear. They don't think that it need to be amended, in my view. RadioTV Radio, if you were asked for recommendation, what do you think? Should this provision remain, or should there be more clarity?
Viewing this from a distinct background, I think it need no amendment because it is clear. Okay, it is clear. The article only trying to portray that the autonomy and impartiality of the judiciary, of every official serving in the judiciary, It is just trying to guard them, guard their steps. That's all.
Okay, thank you so
And
much,
it is
Mr. Griffiths.
Yes, so
You do
everything being said here is very in clear line. One thing I want to highlight a little bit more is every office in Liberia has code of conduct. Every office. So is the code. The code, irrespective of Article 73, has a code of conduct. So if the occupier of the code cannot live up to the expectation of the ethic, the code of conduct, they are with a higher power that can be activated to correct them in any way, manner that is described in the Constitution. And it is always the people that are being affected, their right to come up and speak up so that this thing cannot continue, that are not good for the public. So government does not work automatically on their own. The involvement of the citizen is very crucial to any good governance anywhere on the face of the earth.
Okay, so that if let me go to that Gompu, we are almost our closing stages, but I would need your recommendation. I'll come back to you for your closing. What you think? Should this provision remain? It is clear, or there's a portion that need to be removed, or you think it is just crystal clear?
Yeah, I think the article is clear, and the article is I think the article is helpful as it stands. The only thing I would like to see is that the issue of these protections, there should be some limitations in terms of how long people can be on the bench and enjoy this protection. There should be some way to come back to do a check, such as maybe putting in a term limit.
Okay, so I just have to give my
But
party.
it doesn't necessarily have to be in this particular article. But I mean, right, it's just something extra to say to improve the judiciary. We should limit how long people can be a judge.
Okay, thank you so much, Dr. Gompu. We'll come back to you to do your closing. Abdi J, you can do your closing on this article. And what do you think? What is your recommendation for this constitutional reform? What is your recommendation for the roundtable, for the facility TV a day, as we are echoing this? What you think should be done? What you think is your own recommendation, Abdi J?
Oh, let me say thanks again for the time. You know, we are almost at news point time, but I just have to do my parting comment. You know, it is so essential then. It is so essential for this discussion at all time, because it will like educate our people out there who don't have the knowledge about these things. But for the article, I think this protection is so essential for maintaining a fair and independent judiciary that can dispense justice without fear of re-persecution. Because these people, you know, they need to be protected, you know, to be realistic. These people are making rules and regulations and other things, so they need to be protected. If these people are not protected, I can tell you, they won't do their job to the fullest. So the article is just amended to be to protect them. So it is so essential. So thanks again. I think we are almost in our news time. I hope to join you guys another time.
Thank you so much. The article is essential. That's the voice of Abdi J Radio there in Buchanan, Grand Bassa County. Thank you, Abdi J Radio. So I'm still here with Mr. Griffiths and Dr. Gompu, our panelists. Griffiths, what is your
Mhm.
closing recommendation? You can do that in 2 minutes.
Yeah, even yeah. So as I said earlier on, the citizen has a big role to play because everyone that is in government is serving the citizen. If something is going wrong, you need to say something. If it cannot be addressed, you need to go somewhere and say something until it's addressed. And they are always redressed in cases. If a judge render a verdict in the court of law, it's not the final. They are, I think,
Oh,
district court, county court, there are different stages of the level of court. I won't state it now in the order, but they're always higher court. The highest of the court is the Supreme Court. It is only the verdict of the Supreme Court of the Republic of Liberia is final.
okay. Okay. Let
Any
me let me
other decision is not final in any court.
Okay, let me hold you there before I call that Gumpu. We
Yeah.
want to use this time to welcome our Council of Cabinet Janet, one of our prolific panelists here, our legal luminary, our father, our everything. And today we are discussing Article 73. Why it is true that our radio station they are gone, we are on online, so we have few more minutes we give for the benefit of our audience, so that more discussion can be done on this. Welcome again to another roundtable discussion, Prof.
Thank you. Thank you very much.
Okay, so today we are discussing Article 73 of the Liberian 1986 Constitution. They say no judicial official shall be summoned, arrested, detained, prosecuted, or tried civilly or criminally by or at the instance of any person or authority on account or judicial opinion rendered or expressed. Then let me fast forward. They say except on grounds of misdemeanor, breach of the peace, and that of felony. Now, my question to you, sir. First of all, what is your overview of this article?
Well, the Constitution has to always be looked at first from a historical perspective. In the past, judges were easily removed from their position on account of decisions they made as judicial officers by the president in the past. So one of the things the people who drafted the Constitution sought to do was to put a provision which will give them or protect them, insulate them from those kind of political actions of removal simply because the decision they render are not palatable to the executive. So this was the idea behind the drafting and passage of this as a provision of the Constitution. But Article 73 in my mind is a little bit too elaborate in terms of the kind of protection it seeks to provide for judicial officers. For example, it says statements made and acts done by such officials in the course of judicial proceedings shall be privileged and subject to the above qualification. No such statement made or acts done shall be admissible into evidence against them at any trial or proceeding. Now, of course, on our practice, we tend to understand the full meaning of any provision of the Constitution when it has been interpreted by the court. I know there was one case recently where a judge was accused of sitting in a case and rendering a decision which led to a party losing almost all their money and asset. And it was reported that this person got annoyed and filed a complaint against the judicial officer. And when that matter was investigated, though they did not raise Article 73 as a defense, but to me, it was one of those things that should have been a proper case to interpret this provision of the Constitution. Because it seemed like if you look at the fact that the way the judge proceeded left a lot of questions unanswered. So those are the kind of things. But again, most of these things, while they are intended to insulate and protect judges, they can only fully be understood when there is a practical situation that the court will look and say, was this what was intended or not? So, but I think just from the express language, it appears to me to be too elaborate in terms of what appear to be like a blanket protection, even in the face of what might constitute a serious breach of the law.
So let me say this, and I think that Ogombo will come in. Let me say this. So, most of the subordinate judges and even the higher judges are appointed by the president. And if we are saying that, they have this protection under the law on this article that they can render judgment best of their professional practice. Now, what if you have a big political matter in chamber and this judge, because if he is appointed by the president, we understand there's a code of conduct, but mind you, the Constitution supersedes that. Now, he is relying on this. He's relying on this Article 73. Now, all evidence on deck showing that, this judge is siding with the executive. Does that mean that, and that is to you, that Ogompo, and does that mean that is there any redress that can be done by the legislature or by maybe that individual, that defendant that is involved?
Well, I mean, if this is in the Supreme Court and the judge rendered that decision, I don't know how the Supreme Court operates. Sometimes they talk about the judge in chambers and other things. So I don't know whether when they say the judge in chambers is someone who is there when other judges are not there, or what's the difference between the judge in chambers and the full bench decision. I don't know the details of how they operate. But if we are talking about a Supreme Court decision, sometimes the court can render a decision that is that we all have to accept, even though we disagree. And that's the essence of the Supreme Court. So the order, they render decision, we know that maybe our own understanding of the law and the intention of the law is violated here, and they may have done it for political reasons. We can still disagree, but we still accept the decision and live by it until we find ways in which either that judge can be removed through the legal process or whatever. But I don't think it's even a good idea that because you disagree with one decision, you should seek for that judge to be removed. I think when it comes to things like impeachment, it's a very serious, special situation. So there should be some kind of history to say, the judge always does this. Here are the, evidence. 3, 4, 5 cases that a judge has done this kind of behavior, which is against the interests of the citizens, then maybe the citizens can organize against that judge, or whoever can organize against that judge. But sometimes they will issue decision that you like, you agree with, and other times they might issue decision that you do not like. So I don't think we should just jump to there should be repercussion. We should try to render repercussion on one incident or just on two incidents.
Okay, Mayu, thank you very much. Mayu, they are being paid by the taxpayer money, and the same people gave power in Article 1 of the people, the power is inherent in the people. Before I come to you, Mr. Griffiths, it is always been said that it's good to the alligator come from under the water, so you know what is happening under the water. Let me come to the councillor. Is there any history of this, Prof? Is there any history of this? You have 5 more minutes.
Any history of what?
Of let's say of this big political matter, what that we're talking about, big matter. We know that the judge is appointed by the president. And every evidence, every finger showing that the judgment rendered by that judge, a lot of people frown at it, say no, it's not supposed to be like that. Okay, and he is saying that it is the court decision, to do. Is there any history on that, sir?
Well, basically, there are instances where matters are brought before the court, especially the Supreme Court. But let me just backtrack a bit to say something that Dr. Bongo was talking about. The way the Supreme Court operates is set twice in a year. They call it 2 terms, March term and October term. And there's a break there somewhere, maybe between July and October, or September and October, and then the court will resume the second term, which is the October term. But whenever the Supreme Court is in regular session, the matters it deals with are matters that come from the lower court on appeal generally. But let's say, for example, that there is a matter like in the case of the CBL governor suspension or whatever, there's a matter of that nature, and somebody wants the court to deal with it. The court will always designate one of the justices who will be what we call sitting in chambers. That person's duty is to receive those sort of complaints that are considered matter of national urgency to be dealt with, and don't go through the regular process of going to lower court, then coming on appeal. That justice sits there as an independent justice who will look into the petition that will be filed by that group or that person or that institution and say, we are questioning this conduct on the part of this government agency or on the part of the executive. We think it violates certain rights under the law, under the Constitution, or it violates certain basic laws in the Constitution. It is that person who is called the justice in chamber who is authorized to handle those matters. And if that person determines that this is a matter of serious nature that the whole court needs to deal with, then he will forward it to the full bench. Then all 5 of them will sit down to look at it. That's why they call justice in chamber, just for I understand. Now, yes, there are times where matters come to the court that become very political. And then justice will look at, like in America, he says some people are conservative, some people are right, whatever. For example, liberal. There are those who want to interpret the Constitution, giving the text. They call it the rule of construction. So the text, the way it is written, is clear. That's what I mean. But there are times also where they say, well, you need to look at the intent What did the drafter want to remedy? What was the 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 problem that they tried to address by writing this provision? Now, some of us believe that the better way to interpret the Constitution is to look at the historical context and then seek to appreciate the text from that standpoint and be able to interpret. Take, for example, there was a situation sometime, I think it was 2011 or so. A lot of political parties came together and they filed a petition before the Supreme Court and said that all the people who were running for the office of president were not qualified under the Constitution. Because they said the Constitution say anybody who wants to run for president, you must have stay in the country for 10 years before the election in which you want to participate in as presidential candidate. So when you look at that constitution, when you look at the 10-year clause that you're talking about, it basically disqualifies almost all the candidates of consequence, including the incumbent president at the time. So because they were talking about 10 years, because we had just come back and the constitution was restored in 2006. So if you count from 2006, 6, 7, 8, 9, 10, 11, it was 6 years. So almost all of the people now, Ellen Johnson Sirleaf, George Weah, Charles Bromsky, just name them, all of them were disqualified from their personal interpretation. So the Supreme Court then sat down and said, okay, actually, when the people wrote this 10-year clause, it really means that you must be in Liberia. So that you be familiar with the Liberian situation, with the Liberian state, to understand the condition in which the people are living. You won't have that kind of appreciation. That's what it means. So the 10-year actually means the 10 year before the election that you want to take part. But then the court asks itself, is this provision applicable in this election? So you see there, now somebody will say, well, that political interpretation, but the court will say, look, the first duty of a state is to protect its citizens. Most of the people run away from the country because of the war, when there was no government to protect anybody.
Yeah, but Prof, because you taught me, so I'm just saying Prof. So, but Council, I'll come to Griffiths and Dalagompo. I think they may have the same views on this. I don't know. But again, you said in the 2006 election, whether the code was saying whether it is applicable. Well, I think this is still happening. Sir?
2011.
Yeah, 2011. But this gone 2023 election, we also witnessed people coming from the diaspora who have not resided in the country prior to that time. They were coming and still they stay wrong. So Griffiths, I will come to Dalagompo. I'll come back to you, Professor. I just got information from the television online saying they gave a few more minutes, so we can remain on. They are happy. The viewers are watching. They are happy that they are being educated by the panelists. Griffiths.
Yeah.
Is there anything you want to say regarding the world Council has said?
Yeah, the Honorable Councilor made things very plain, and that's what I kept laughing. And he talked about the political side. And, the power that bees, a philosopher once said, justice is obeying the will of the strong. It might not be inherently written in our Constitution in black and white, but sometimes it's not literally what it's written at the council keep referring to, for us to be flexible in perceiving how judgment are derived. Because some judgment, as he said, it comes from our historical context, contemporary context, and applicability of that in that dispensation. So there are so many ways you can look at things. That's why it is always important for people to be part of the process. Always push these powers, the citizen now, push these powers that if you're saying this, we're going to hold you accountable. Accountability should always be on the table as another strain from the people themselves to be part of it so that they can lose their country. Because it will leave political issue to continue to be unchecked. Like he clearly said about 2011 election, most of the candidates that were supposed to have won were not qualified on one clause, but they were qualified on different clauses that allowed them to sit at the table.
Okay.
So if these candidates were going to all be denied, I believe the election was going to be a disaster because feeding in candidates that popular were not expected to win, another person can come and say, hey, because you deny our candidate, we're not allowed the election to go on. So there will be going to be a lot more trouble than allowing them to say, hey, any other library will not deny based on this historically.
Okay.
And since there was no historical content of denying any Liberian from participating in the election, so those candidates were given a leeway. But a historical precedent was going to be set.
Thank you.
Then, the 2011, it will have to be upheld.
Thank you.
I
Thank
think
you.
the councillor can allude to that.
Thank you. Da?
You're welcome.
Yeah, I think that's a good example. And I think the court made a reasonable decision under that circumstances. And I think that domicile clause, I mean, I don't know whether it is really implementable even in normal situation, you know. So I think the court acted wisely in that situation because, I mean, who is keeping record on who's in the country and who's not in the country, giving the structure of our borders and all of that. See, so in the case of elections, I think it's best for the voters to decide rather than one candidate going to sue another candidate and saying, oh, you were not here because I know you were in South Africa or I know you were in this place. And then the court ruling that, oh, yeah, this person was not here. And clearly it could lead to chaos where, as suggested, Mr. Griffith suggested that the other people, the person's constituents might feel denied. So I think the court made a good decision in that case.
Council, okay, thank you very much, Dad. We got 4 more minutes. Council, there's this text message from a group, Liberians in Cairo. Now they are texting. They say we should ask this question. If for any reason a justice in chamber come up with a ruling based on the Article 73, they are asking whether the legislature have the power to checkmate for any reason if they think there's a need to call that judge for inquiry. They're asking if there is a tendency that if there is a means that if a judge carry on a ruling that the legislature feel that no, I think we need to question this judge. Like maybe in the case of Nelson, I will use that to use it as a research issue. Chinny concerning Jessica Law and Lucas Riches. We're hearing a lot of ways of saying that the judiciary, we heard the speaker at the time say, oh, they should see how they can, They are asking, well, is there any, benchmark for that?
The Constitution grants no such authority to any member of the legislature, not one.
Hmm.
The process for reviewing a decision that has been entered by a judge or a justice sitting in chambers is an appeal process. And there are other remedial processes you can file for the Supreme Court to review that person's decision. But no other branch
Hmm.
outside the judiciary may properly exercise any authority to review the decision entered by a judge. No, not on our constitutional democracy.
Wow. 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 This is absolutely again. Let me. This will be my second to the last question. Anybody can chime in on this. A judge is supposed to be to work at 9 a.m. in the morning. We understand how our traffic is in the morning hours, and he's supposed to be to work at 9. Apparently, because of the traffic, we understand that sometimes some privileges are given to official, and this judge or try to use the opposite lane, and then anybody can chime in on this, and then unfortunately, uh, something happened that not supposed to happen, accident, you know. My thing is that my question is that is this George acted unprofessionally by right his case? Should he have been in the rightful lane? By using the opposite lane, he have taken away lives.
Yeah, but it's not a constitutional question. It's not a question that you want to ask me, but me, anybody can answer that. But I think there are traffic rules. If a judge acts outside that and there's an accident, the same way anybody will be held liable for their conduct, so that judge will be. Now, when you talk about privileges and things regarding the conduct of a judge, those are things that are limited to actions, statements they make in the discharge of their duty as judicial officer. Not outside that, no. So yeah, if the judge is taking different route and then there's an accident, the same way you hold any driver responsible for accidents, so too you will be held. At least that's the way I understand the law.
Okay. Okay.
I agree with that. I agree with
Yeah.
that. There are protections, but officials have to also be citizens as well. So it means that they have to use good judgment and abide by the law. And violating traffic rules applies to judges as well. I mean, the rules of traffic apply to judges as well. So I agree with that.
Yeah.
Okay. The last question from Atari Shabi there in Nukutan. They are saying we should ask the council. The question coming to you, council. They say they should ask, saying that he's saying what he's saying is coming distorting. But let me make them grab some pieces of it. They're saying that most of the team has been said here by either of you of the panelists. Say it is fine. People are discussing well, but they are saying these things are not happening in Liberia. The reality is that they say they have not witnessed any kind of form where a judge, outside the courtroom, done a crime outside, like misdemeanor, because I want us to dwell on this just for a few minutes. They have not witnessed for any reason for what judge been held liable. They are always been protected either by the police, they have been protected. I mean, people feel they are official for any reason.
Can they give examples? Can they give examples? Specific date?
Example. They still mentioning this traffic issue, but you have answered it already. So we not talk about
Yeah, but
that.
that statement is in fact not correct. It's not correct. There are rules that govern every profession. So too there's a code of conduct for judges. Okay, I give you an example. There's a code we call commercial code.
Yeah.
There was a judge there who acted in a manner that persons who felt affected file a complaint against that judge. The matter was referred to the committees under the Supreme Court called Judicial Inquiry Commission. That is mainly for judges when people file complaint against judges, whether they're magistrate, the circuit judge, or justice of the Supreme Court.
Yeah.
And in this case, if it is against a judge, then one of the Supreme Court justices will chair the committee. Okay? If it is against a justice, two of the justices will sit on that committee. So this guy, they reported this complaint against him, and they say the way he did in that case was unprofessional, unethical. And the matter was investigated, and the Judicial Inquiry Commission recommended that he be forwarded or recommended to the legislature for impeachment and removal. And the evidence was so convincing that before the letter even reached the legislature, he tendered in his resignation. That was an internal mechanism that was used, but applied properly, and this judge saw it maybe proper for him to just go away from the judiciary, and he was removed. And we had similar cases against magistrates, quite a good number, and they are all published. It's just that, we don't have a society that likes to read. That's part of it. But those things are there. But a major one was that judge who was at the commercial court. And
So
it was
is
a
that
very-
is that commission a standing commission or an ad hoc commission?
It is a standing commission.
And
It's
are
there
the
as part of
citizens
the organs of the judiciary.
are citizens
fact-
aware of that commission?
Oh yeah, they are. There are many complaints that and in fact, it used to be only judges and lawyers. The Supreme Court decided to expand it to bring in some credible people from civil society who are also members of these two commissions. One is the Grievance and Ethics Committee, which is basically against lawyers, and then the Judicial Inquiry Commission, which is against mainly judicial officers. There are people only who are non-lawyers, just to sort of inspire confidence in the thing. I know that there are two religious people on the committee. In fact, one of the most credible lady in Liberia, Sister Lorraine Brown, is member of one of the commission. It's a standing commission.
Okay,
There
so
are
how has the judiciary, what mechanism has the judiciary put in place for citizens to be aware
Thank
that
you.
these commissions are available and they are there to serve the public? Has there been any resource applied to that? Because myself, I'm just hearing about this as well.
Oh, maybe because you don't follow on judicial news, but it's there. It has been there because this code came into being 1999. It was reviewed 2000, and then review again while I was with the code. So these two bodies have been there for forever. And whenever their decisions are made, they are published. Yeah. But that's the way. And it's simple. You just write a letter expressing what your grievances are, is addressed to the Supreme Court. The Chief Justice receive it and send it to the committee, the relevant committee. If it's for magistrate, they will send it to the Judicial Inquiry Commission. If it is against a lawyer, it will be sent to the Judicial, the Grievance and Ethics Committee. And actions are taken. In fact, there was one against the former president of the Bar Association. And the Supreme Court investigated that matter and disbarred that former president.
Yeah,
he remained disbarred until he died.
Yeah, but
and the lawyers, when they disbar you, when you die, your police can't even go to your funeral as lawyers.
Oh.
Yeah, I think these are good instruments or institutions. I don't know how to call it. Yeah, but the citizens should be educated. Citizens should be educated about it. I think that the judiciary is supposed to apply some resources to within its budget to educate citizens about it, because look at us on this show. How many people on this platform, other than you, are aware? Other than you, Justice John, are aware? You know, I've heard about the judicial ethics
for you. Committee. You may not know, but all the other people.
No, I don't know either because sorry, Doug, I come in because the question are coming to me that I don't know. I really don't have a clue. Welcome, Mr. Alex Jones, the leader for movement from the Make Liberia Better. Will come to you, sir. But people are saying, "Oh, we know the TLE, but I don't know the post about." But that finish, they put ask the question. They say, "But let him tell us the procedure." I mean, can ordinary person that read letter or grievance and walk to the temple doctor?
That's all that is required. You say, "I'm writing a complaint against Kabine Jane, who is justice, blah blah blah, or this magistrate, because on so time this is what he did, and it's a breach of our law, whatever." And then you send a letter to the office of the Chief Justice. In fact, there's even discussion now to see how it can be decentralized so that the county, because every county gets its professional group, so that the group now will be put in charge of those complaints, just to make it easier for people to be able to file complaint. But that's the way it does. Just simple complaint, you file it with the office of the Chief Justice, and it will be sent to the appropriate committee, and it will be investigated, and the report will be published. It's not like those police who they have an investigation, you don't ever hear. No. The report is published.
Yeah, so let me come in on that. So we are not hearing you again.
Yeah, that was saying that you're in flight. I just cut you.
No, I was just taking a quick sample. Mr. Toh, are you aware of this this commission that? Were you aware of it?
No, I was not aware, but I knew always there was a grievance way to amend grievance. That's why earlier on, when you hear me say, I'm saying the citizens need to ask questions, they need to be involved, that they need to look for accountability. That's the reason I was saying that, but to know exactly the name and address, no. But I knew always embedded in our civil society, there are mechanisms that are there to listen to grievances. That's all I knew. But he gave all the address. And this is one of the reasons I made time for this show, and I love this show. Because educate me.
Are you aware of this commission?
Well, no, absolutely not. I'm not aware of it.
Right. So basically, I mean, imagine I mean, of course, they say what's the term? Ignorance of the law. Excuses no man, something like that. So if it is there and we don't know, they are not responsible. But I think if people at this level are not aware of this type of institution that exists for redress, then imagine, the illiterate Liberian, or imagine a Liberian who is just at the level of a high school dropout, which constitute more than 60% of the Liberian population. So it tells us that we have this kind of beautiful structure that is there for judicial redress, and real serious efforts need to be made on the part of the judiciary as well as other agencies of government to educate citizens about these kinds of rights, these kind of opportunities that exist.
And let me say this, if I can, Justice Janet. So I just checked the judiciary website, and there is a committee. It's called the Grievance and Ethics Committee, but there's no information as to how anyone, and I'm looking at it right there. I don't know if you can see it, but there's no information as far as this would be the place where if I have any grievances, I would submit, So I think that, buttresses Dr.
You
Comfort.
show you personal their function and duty of the judicial inquiry.
It says coming soon. It says, and I'll put in a link. It said content will be uploaded soon. So I don't know how long it's been there.
It will take 5 more years, please.
Correct.
I think that's a problem. There is supposed to be part of that information to say this is the Judicial Inquiry Commission or Grievance and Ethics Committee. If you have grievances, this is what you do. I think that should be the frankly.
Okay, thank you very much, Mr. Jones.
Yes, sir.
Quickly, we are running out of time. We are discussing, or we've been discussing Article 73 that the Compu elaborated more. Mr. Toll Griffiths, the justice himself, talk more about it, talking about no judicial official shall be summoned, arrested, detained, prosecuted, or tried civilly or criminally by or at any instance of any person or authority on account of their judicial opinion, rendered or expressed. Fast forward, it comes down to say, except as done in the course of a trial in open court or in chambers, except for treason or other felonies or misdemeanor or breach of the peace. Okay, statements made and acts done by such official in the course of a judicial proceeding shall be privileged and subject to the above qualification. No such statement made or act done shall be admissible in the evidence against them at any trial or proceeding.
So in the face of that, how can a legislator summon you?
No, they can't.
Right.
They can't.
Right. And I was following the show, this is an area that I look to people like Justice Janet for guidance. That's his expertise. And he was very clear. I think you gave the analogy of someone driving on the wrong side of the road and, violates a traffic sign, and that person happens to be a judge, and I think it's straightforward. I think it's clear. He's not performing his judicial responsibility. He's an ordinary citizen. You have rule of law, and everybody should follow the law. And so I think that I don't think there's any question or it's befitting that people should abide by the law. My problem here is, and I think we discussed that last night, I feel there's been some controversy over if a president leaves power, right, and he commits a crime, like let's say for the instance a rape, something like that has no bearing on the function, just like the judge. Can we go back, and if the crime is discovered after his presidency, can we go back and hold him liable for that crime, just like the judge who is committed a crime that has nothing to do with his function or his opinion? That's my question for Justice Janet.
No, but like you said correctly, when they say action taken by the president, Honor Article 61. Let me see if I can just find it quickly. It seems to be very clear. It says the president shall be immune from any suits, actions, or proceedings, judicial or otherwise, and from arrest, detention, or other actions on account of any act done by him while president of Liberia, pursuant to any provision of this constitution or any other laws of the republic. Yeah, isn't it contemplated by the draft of this that there will be matters relating to his function as president, his duties as president, to go really now presidential thing?
Exactly.
No. So if it is found, because the question will be, even during the presidency, suppose it is discovered that the president has done this, and people decide not to investigate it, then he leaves office. So the question will be, can you go after him for that crime? My view is yes, because it is not part of the duties of a president.
Correct.
Well, this one is talking about where is it the president has see money, this, that, then they say that security is doing. To go after the president for that would be a Herculean task.
So you see, in terms of certain corruption, where I don't think part of the president's duty is corruption. So if the president pocketed money, they can go after him because that's not part of his duty to steal money or embezzle money.
But then to determine as a corruption, you will first have to show that there was a violation of the law. Now, so if you see the president took $30 million and it was spent on an NSA, and then the president said they were for security matters, what do you do? And then the Security Act says the president is not supposed to divulge certain information because that itself constitutes breach of security. So how you go about that? It's not as simple as people think.
Okay. So what I'm saying, can the current attorney general, right, goes back and investigate a potential crime of the president? Is that possible?
My view is that those that are not security related, probably, but those that relate to national security questions, I don't know how you do it. I have been Minister of Justice, and I know that there are certain things you just can't say. And the law protects you from not saying those things. So if you can't,
but as the current Minister of Justice, you are not divulging any secret information to the public. I'm sure you have security clearances to go back and check, right, in your investigation. And if you find out, for instance, let's say you discover that a president has like $20 million in a Swiss bank account during the time he was president, and he did not disclose it. Are you saying that because it might be related to national security, so independent counsel or justice minister can investigate that and charge the president if found guilty?
No,
can I come in?
That's not what I'm saying. I think this will cover a whole time.
Let me come in and make it short.
Yeah, 1 minute. I'm saying the president I spent $100 million on national security. Some of their money passed through, blah, 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 blah. And he said, that's all I can say. I don't know how you are forcing to say anything more than that. Because national security itself requires concealment of certain information. Now, if you can trace that money to a Swiss bank account, that's a different situation. But until you do that, I don't know how you will charge him for crime.
Well, you can subpoena, you can depose him.
No, you can't force him to talk. No, sir. You can't
Okay,
force
but
me.
you can
In
get a
fact, one of
witness.
my right. Listen now, listen. One of my constitutional right is not to say anything to you
Right.
if you investigate in crime. Now, so
Correct.
on our law, I have the
Yeah.
right not to say anything to you. You got to go find your evidence.
Okay.
Mhm.
Yeah, that's the law.
Okay.
Clear and simple. In fact, when you call me for criminal investigation, the law, the constitution says you must tell me, my man,
What
you
I
have
did.
investigating you. You have right not to say anything to others. That's what they call the right to remain silent.
Correct. But during the trial,
Mm.
after you've been indicted, during the trial, they what you call it? The prosecutor can subpoena documents from a bank account that the president has. And if that bank account shows when money went into it, that can be used as evidence, and
But
that
you
can
just
lead
said
to a
it.
conviction.
So that investigation without me, now so without the president,
Mhm.
you do your investigation.
Right.
That's a different situation. But
Yeah.
you're not coming to me, the president or former president, to ask me to tell
No,
you. No.
no. Right.
That's the point I'm making.
So,
You see,
Mr. Griffiths,
most of the time, the reason why
Yeah.
we are unable to successfully prosecute crime is because we rush to arrest, indictment, and then we go to court, then we can't produce the evidence.
produce the evidence. Yeah.
Mhm.
It's
Got
good to take your time and do proper investigation and put all your evidence in place. Because when you go to the court, especially for crime, that man can just sit and just look at you. You do all your thing.
Mhm.
Mhm. So
I think.
we just have bad prosecutors that don't do proper investigation, and
Well,
that's why they don't
I
convict
can't
anybody.
say that, but I can say that oftentimes we rush to to arrest an indictment. Then at the end, when the court says they can't present the evidence, we're not ready.
So you can come in, Mr. Toe.
Yeah, what I'm trying to say in simple fraction is that it's very difficult to bring anything at the feet of the president because the president have so many entourage that do his bidding. So if there anything you had to read to the president, you had to go on through a trail, maybe from 1 to 99 conviction. The president might be the 101. But to just come straight to the president, you don't lead anywhere. But you have to go around the president a web, like a spider web. When you start your due diligence, follow a trail. For example, is it a crime, like a murder? You follow the trail, it will lead, answer will lead to answer, and answer will lead to discovery. If you have to go through financial embezzlement or stealing, you have to know, for example, this is 10 million Liberian data that were missing or misappropriate. Why? Because we're supposed to build a guest house for Liberian people in Bapolu County. And if that money was spent and we cannot see a physical house, we go after that particular money. And through investigation, if people answer questions, it will bring discovery. And if none of those people ate the money and if the president that told maybe 6 million of that money, those eyewitness with evidence going to say, hey, I didn't eat the money. Under the directive of my boss, I place the money here. You go to his boss, under my directive, I place the money here. You go to the other boss, and then a lot of claim, right? The trail might get to the president to be the last person to answer the question. So at that point, with all the eyewitnesses and documentation, you can finally know who actually spent the money if people are willing to talk. So I think the counselor can elaborate on what I just said.
Before he comes here, I got one question for you again, Justice General.
Okay.
Is misappropriation a criminal charge?
I think that was
It is
Yes, it is a crime.
misapplication,
Mhm.
embezzlement.
That's what I was just talking about.
economic sabotage, all of those things, they are nothing but stealing, theft.
Okay.
It's just that they are put on a different nomenclature on our
So let me get my follow-up.
They are all stealing, and they are second degree felony. which means you could go to jail up to 5 years.
Excellent.
In
All right.
addition to the restitution, you must pay back.
Oh,
Okay.
okay.
So in other words, right? One of the problems in Liberia is most misappropriation. I think we all can agree with that. And I think
Yeah.
if you were to really investigate, almost every minister will go to jail for 5 years because the budget
Yeah.
allocation that says, hold on, the
Maybe
budget
there are some
allocation
holy
that
I
ones
says,
know.
there.
hang on now.
I know
The
about
budget
that.
allegation that says, for instance,
Oh,
the finance minister supposed budget is appropriated to grow the economy, to do X, to manage, different function. So if none of those things are done and we can measure them, obviously that money has been misappropriated. You agree with me on that point? Money was
Where,
given for this purpose. We got the
Yeah.
opposite.
right. You know, under the Constitution, there are two things that are important for us to remember. All public monies, so money that are paid through different taxes, they become public money. That's all.
Mhm.
Now, all those money to spend them according to our constitution must be authorized by the legislature, which we call appropriation. But when the monies are collected, they are deposited in a government account, which we call treasury, the public treasury. The law say when the legislature has even said we're giving $10 million to hospital, we're giving $20 million for education, $5 should not be taken from that treasury unless by warrant signed by the president. You see the thing again?
Right.
So they are probably just one side. But to take a dime, a nickel from there, the president must authorize that. You see that again?
So if you go by that, if you go by your statement, a lot of people have problems.
okay.
Precisely.
Okay. So
Bossman,
we are
you
running out
know,
of
and
time.
this is where most of the time people will say we are misunderstood in Liberia, because the day you go after any former president to say they did so thing, someone will come and provide free defense if we believe you're not proceeding properly. We will.
So
We got to be a country of the rule of law.
That's right.
You don't like the law, fine, change it. But you can't
Right.
disregard it because you don't like it. No.
right.
So
One
the
more
day you
question.
try that, then we come and just say, well, we will see the law differently. So let's test in a code of law.
That's right.
One more question, and this from the biggest attire shop in Liberia, which is on Center Street, no, Kerry Street. I think called it CO. Eh? Yeah, I should ask you, counsel.
Yeah, that one place there.
Yeah. they say I should ask you, and anyone can maybe follow up on that. We got less than just in 2 minutes. So
Yeah.
just states they're asking that the constitution says presidential appointee works. They want to digress a little from this article. They say the constitution says that presidential appointee works at the will and pleasure of the president. Will and pleasure of the president. So what if you have an integrity institution, like the anti-graft institution, LACC, or maybe all the GAC, or maybe even in your capacity, at the judiciary? Does that mean to say that the president can wake up one morning, and say, okay, no law supersedes the constitution, even where there was executive law, where there was code of conduct, where there was any other law, the constitution says presidential appointee nominee work at the will and pleasure of the president. For how many security reason, let the president go sit down. They are asking, what's your take on that?
The three branches of government, the branch that is authorized, the branch that has the authority to say this is the law. They read the law and say this is what this law means. It's only one authority, and that's the judiciary through the Supreme Court of Liberia. The Supreme Court has interpreted most of these things. One of the first questions that President Weah raised when he became president, again, in the greed for power, he says, look, all the things your party, your court, 10 new positions, they are all unconstitutional. He went to court, or he was taken to court. The court said, no, Mr. President, your authority to appoint is limited by the provision that say the legislature can also create agencies. It has the authority to create agencies and provide how those agencies are supposed to be run and guarded. So there are two different powers. It is not true that because the president has authority to appoint, therefore he also has authority to let the person go by will and pleasure. It's not everybody that the person that appoint he can fire.
So what if now they are saying, what if now this integrity, because they say it's happening now, it is unfolding. Why is it this very integrated institution, the legislature has the power to create, maybe they are called agents or whatever it is. Why is it now it is happening that president work one more and say, okay, I don't have confidence in these people that are working, so let them go sit down. And some people start down and say,
they are tired people that are asking the question. They know I can't answer it because it's a case now that is before the Supreme Court.
Okay.
Yeah. And our ethics as lawyers is that when a matter is pending before the court, we are not supposed to discuss it. We wait until the court decides, then we can have discussion on it. So that's it. I have a very clear view on this regarding whether the president can do the thing that he say he do at the CBA. I kind of but let's wait until this Supreme Court speak to the issue.
But Justice, I mean, we hear all the time here when there's a case in court where you got commentators or you got legal expert talking about the case on CNN and so forth. How come in Liberia, or expert like you not, or professor not allowed to give his opinion before doing the trial?
Because we got two different professional ethics. Their own, they are allowed to do so, but in our own, we are not. For example, on our code, you are not even so to publicize like the way you see on American television, they talking about their law firm is special. Exactly. But under our rule, as rating today, we can't do that. So these are some of the reforms we're talking about that we need to do in the system.
Okay.
You know that if you are a professor of law in any university in America, you want to come teach lawyer at Liberia, you are not allowed to
you got to be part of the bar, right?
Now some of those rules that we need to change.
Right. Yeah.
But that's how it is right now. So let that person wait there and say, I'm coming to the Hatay place, that we do Hatay. So but the case got to be decided for by the Supreme Court.
That's what I want telling man who say he actually even behave like you should know himself. So okay, boy, can we come to the close? We are now coming to the closing stages of our discussion for today. We take our closing remarks from, first of all, start with Mr. Tool Griffiths and your recommendation for this program concerning some provision in the Constitution that need to be discussed and need to be amended. Mr. Griffiths.
Yeah, thank you. I wanted to buttress before about the comment. The councilor can't comment, but we the lay people who can comment because we do not have code of conduct or liability upon us. So I wanted to make that clear. Him is exclusive. He's in the club. He cannot give opinion. So have they asked any other panelists, we will adapt deep into it and give opinion. Because we are at liberty to discuss it, and we are not, constitutional banning. Like professors, like judges, like justices, we are free as Liberian citizens to just talk anything, even if it is before the Supreme Court. So let me make that one clear, please. However, let us continue to have this deliberation. And I love that Liberians are paying attention. I will encourage my fellow brethren that we should fear nothing but fear itself. Let fearlessly discuss things. Now that we know how the grievances from the Chief Justice, we know that it's on the website. So another thing we need to push that Chief Justice, if the budget didn't allow you to include that part on the website, Honorable Chief Justice, please put the money there or President add the money. Let Labrador website and be running. Because there are times I went on NEC during the election, I went on NEC website to look up information. A lot of information were not there. Sometimes you go to the Labrador National Police website, the website are too shallow. So I think what I would say is that Liberia government should kindly update, folate their website so that Liberian can be able to access what they need to access for the rule of law to continue. Thank you.
Thank you so much, Mr. Toll Griffiths. Thank you so much. Mr. Alex Jones, your closing and what's your
Just be quick.
recommendation?
Yeah, and I agree with my brother there about, information getting to the public. Most times when we talk some of these things, we do our research, we'll say, oh, you're not here, right? So I wonder the people who live outside of Monrovia, who don't have access to come to Monrovia for information, how they can get the information. Because I would think that the website doesn't just serve people outside the country. It serves the people throughout the entire thing. And about the misappropriation, we got currently our House of Representatives. They don't have a website. Is that misappropriation? Our executive master, some ministry in Liberia, even though in the budget, the money allocated for technology. So if we want to use the law, then all these administrations have violated the law because they are taking our money and they're giving it, putting it somewhere else. So that means, according to the good old justice, to prove that is very simple. Just look at that website and look at how much was allocated in the budget. Right there, that's the head of that entity have committed a crime of misappropriation. Yeah, I can go ministry after ministry after ministry, and you'll find it all guilty of that as charged.
So, what is your recommendation for the roundtable for this facility concerning the amendment of the Constitution?
Well, I would just stick with Justice Jenner. I think I will follow his lead and what he recommends because this is the area that he has expertise in. I think he's profound in his, very balanced. So, I like to go with the experts. So I will whatever recommendation he comes up with, I will second it. But yeah. So I mean that's just my take. I think it's a good program. I think we should continue to do it. And I highly applaud you. If I were president, you be Supreme Court. You go back to your position of Minister of Justice. For the simple fact that you are able to come and educate us.
Yes.
And I think all public officials, past and present, should do the people a favor. It's part of the obligation to enlighten the public. And you are one of the first person I've seen to come down to the level of ordinary people like us and educate us based on your experiences and your knowledge. And that is commendable. People should do that. So thank you for your service to the country.
Thank you. Thank you.
Let me say one second thing. And also, Honorable Kabiden Janet, it's a privilege to be on the panel with you. I love you. I heard your story from a distance, and you always have my admiration. So I just wanted to say that we love you, even though many are haven't met you. But God bless you again. This is how humble you are. Thank you.
So before we take our closing remark from Justice and his recommendation, people are commenting that thanks to Justice for adding value to the discourse. To the discourse, yes. They are so happy, and for at least taking an extra time out of the 1 hour, people stay watching from different angles on YouTube and stuff like that. Also, they are saying thank you to Alex Jones too and Griffiths and that people that left. So that Council, what would be your closing recommendation, Justice?
Yeah, okay. I want to thank you very much for the kind words you have expressed. Generally, I have always seen the Constitution as an instrument that we need to commit some time to discussing. I have been teaching at the law school now for a little over 10 years, and this is one of the things I like to do. Of course, there are many criminal justice administrators today in Liberia that have been able to teach just to improve the criminal justice system. So we'll continue along those lines. But I wanted to make one quick comment. Now, it's not sufficient, Brother Jones, that an appropriation has been made for a particular task, and then you say it is misappropriation. Because the second part would be that in addition to the appropriation, that the money was in fact made available to the agency to do the work, which now become part of the presidential exercise of presidential authority. Because the president does not sign a warrant, though appropriation has been made, that agency will have no access to that money physically. So that's the other one. Now, I think these are very good, platforms to interact with Liberians around the world, so that we can understand our constitution. This is the fundamental governing instrument.
Yes.
And this constitution was drafted by people who wanted it to be a living document. It should be disseminated to all Liberians for also discuss and be familiar with. That's why Article 10 of the Constitution, it says it must be published and circulated for Liberians to understand what they have as the governing instrument for our country. So I want to thank you guys very much for organizing a forum like this. And whenever we are available, we'll be part of it. So thank you so much. We appreciate this.
Thank you so much, Justice. Thank you, Mr. Alec Jones. We thank you, Mr. Toll Griffiths, and all our online viewers and those that weigh in their calls from our sister radio station across the country, from the biggest attire shop there on Kerry Street and our Liberian community in Cairo. We want to say thank you for being part of this discussion today. We hope to be back next week, Tuesday, for another fascinating one. With that, we say thank you and have a God bless day.
Thank you.
Thank you.
And Mr. Jones, see you soon.